So when I talk about, the mistakes that people make, if they went to an estate planning lawyer who didn't know elder law, their will won't have what I call an asset protection trust in it. An asset protection trust is the type of a trust that in the state of Washington, the state says, oh, one of the spouses has died. They put all of their estate through their will, through the probate process, into this particular type of asset protection supplemental needs trust for the surviving spouse. Okay, we honor that, says the state. Let's say the decedent's share of the estate was $500,000. So $500,000 went into the trust for the surviving spouse. When that surviving spouse qualifies for Medicaid, is that money going to count against them? No, it is not. The state says, okay, you've got $500,000 in trust. We don't count that. All we count is the assets that are in your name. So a couple who lives in the state of Washington can, with assurance, protect at least half of the assets for the surviving spouse against the necessity of spending them down once one of them has died. That's what an elder law attorney will virtually always include in a will for somebody who's concerned about long-term care costs, which frankly is the majority of people, especially if the asset level is $2 million or less. Protecting assets against long-term care costs, that is a skill and expertise that an elder law attorney will bring to the table for you. And by the way, it's not just against long-term care costs, it's against any other threats like this asset protection trust protects against estate taxes. It makes sure that the assets of the deceased spouse will go where the deceased spouse wanted them to go, which means that it'll go perhaps to the couple's children or whatever they decided upon. It's the assets in this trust are immune from any creditor's claims. So it really protects assets from multiple threats, not just long-term care threats. Another thing that I wanted to point out about working with a qualified legal advisor that is an elder law attorney and not just an estate planning attorney is that if you ever do need any asset protection in the future against long-term care costs, the attorney is going to be that same attorney you worked with. We don't have to refer off somebody. If I was just an estate planning lawyer and I knew nothing about elder law or Medicaid or government benefits or Medicaid asset preservation strategies, if I didn't have that level of expertise, if we didn't have that at ELG Estate Planning, I would say, I'm so sorry, I can't help you. I don't know what to do. I have to refer you to an expert who has that. So if you start, and when you're working with somebody on an estate plan, even if you're younger, even if you don't, heaven forbid, nobody wants long-term care in their future or disability, what's the benefit of working with an estate planning lawyer with elder law expertise? They'll be with you for the rest of your life. They can help you no matter what happens. You will not need to be referred off if long-term care does come up in your future for you or for your spouse or family members. You are with that legal counsel who can guide you through that journey, no matter what happens in life. And of course, handle your estate upon death. So the benefits of working with an elder law attorney, and that doesn't even, I'm just talking about the legal benefits. Having been through 14 years of long-term care with my own parents, I understand that there are a lot of resources that are out there. You don't have to do this on your own. It's not just the legal help you get, it's knowing that there are people called, aging care managers and who to contact for, do you need an estate sale? Who do you contact? What plan should you be putting in place? Somebody that's been through a long-term care experience has a wealth of knowledge that those who haven't been through it wouldn't be aware of and wouldn't know those resources. So Again, obviously, as an elder law attorney, I recommend that you work with an elder law attorney if it's appropriate for your situation, which means that you're not at that, federal taxable estate level, and all you're trying to do is avoid paying estate taxes.